I had wanted to start with remarks about the honor we have had in my country of having distinguished judges from Trinidad, including a former Chief Justice, Judge Philip Telford Georges, who was greatly appreciated in my country, and late Justice Uri Cross, who was also a distinguished jurist and dean in the Faculty of Law in my country. I also wish to refer to distinguished international jurists, starting with the President Carmona, who spoke this morning, who had a distinguished career in The Hague. He heard his eloquent and powerful statement about climate change, the preservation of the marine environment, and IUU fishing. We have the late Justice Judge Lennox Barra, who has been referred to, and of course my distinguished colleague Judge Anthony Lackey. My presentation will consider the legal regime of the phenomena of piracy and armed robbery. It will discuss the main causes of the two phenomena, the challenges to the overcoming of these phenomena, and I will conclude with the way forward. But let me start with a few general comments. First, piracy is an age-old phenomenon. It has taken different forms over the centuries. There was a time when piracy was legal in the form of privateers who were authorized by their governments to attack and pillage ships of enemy nations. The 1856 Paris Declaration abolished all forms of piracy. The declaration was a decisive turning point in the fight against piracy, according to one author, Dobie. Today, piracy has been outlawed by both conventional and customary law, as I shall try to illustrate. My second general comment is that maritime piracy has declined from its peak of a decade ago. According to statistics by the International Maritime Bureau, there were 191 incidents worldwide in 2016. Pirates and armed robbers attacked 43 ships and captured 58 seafarers in the first quarter of 2017. In spite of global piracy reaching the lowest level since 1998, crew kidnappings increased in 2016. Maritime kidnappings showed a threefold increase on 2015. In 2016, 62 people were held for ransom. Half were captured off the West African region, and 28 were kidnapped in Malaysia and Indonesia. So while piracy and armed robbery could be a possible problem in the Caribbean, I presume it's not as much of a threat as in some of these regions like the Somali coast, the Gulf of Guinea, and Southeast Asia. My final general comment, it may be observed that whereas the global phenomenon of piracy has reduced, maritime violence in the form of kidnappings and hijackings for ransom have increased in the Gulf of Guinea, which I just referred to, and the Southeast Asia. I turn now to the legal regime of piracy. The legal regime of piracy has been codified in Articles 100, 107, and 110 of the 1982 Convention on the Law of the Sea. The UNCLOS provisions repeat almost identically Articles 14 to 22 of the 1958 Geneva Convention on the High Seas. The definition of piracy urgentium in Article 101 of UNCLOS is identical to Article 15 of the 1958 Convention. Elements of piracy include, first, the definition which I will mention of piracy has these elements: an illegal act of violence or detention or depredation committed for private ends, that is, all acts lacking government support or sanction. These acts have to be committed by the crew or passengers of a private ship or aircraft. The acts of piracy committed by a warship or government ship and aircraft are assimilated to those committed by a private ship or aircraft when the crew has mutinied and taken control of the ship or aircraft. This is Article 102 of the Convention. Piracy is an exception to the exclusive jurisdiction of the flag state. It is the only exception for which customary international law provides for universal jurisdiction. This universality principle is reflected in Article 105 of the Convention. This does not require a connection or nexus between the defendant and the prosecuting state, that is the universal jurisdiction. Under international law, piracy requires the presence of two ships, the pirate ship and the victim ship. In some municipal law, piracy can be committed even when one ship is involved. The requirement that two vessels, the pirate and victim ships, be involved distinguishes piracy from hijacking. Thus, attempts to seize the Portuguese vessel Santa Maria in 1961 and the Italian liner Achille Lauro in 1985 were not acts of piracy. The hijackings were politically motivated and were akin to armed robbery. Secondly, the geographical scope of piracy urgentium is the high seas. This is another factor that distinguishes it from piracy in some municipal law. Pursuant to Article 107 of the Convention, which I referred to, on the high seas, every state may seize a pirate ship or aircraft using a warship or military aircraft or any other ship or aircraft on government service. The universality principle in Article 105 does not authorize the seizure of a pirate ship or aircraft in territorial waters, archipelagic, or internal waters. The exception is off the Somali coast. This exception was prompted by the United Nations Security Council when it adopted several resolutions, which led to a unique situation in the international law of piracy. Resolution 1816 of 2008 authorizes the cooperating states to pursue pirates and armed robbers into the territorial waters of Somalia. Security Council Resolution 1816 makes it possible for international law rules on piracy, which apply on high seas, to apply also to the territorial waters of Somalia, thus permitting pursuit from the high seas into territorial sea. The Somali situation was regarded by the Security Council as sui generis. The uniqueness of the situation of the Somali coast is testified to by the fact that no expansion of the geographical scope of Piracy Urgentium has been done by the Security Council to other regions affected by piracy, such as Southeast Asia or the Gulf of Guinea off the West African coast. It may be observed here that Article 58, Paragraph 2 of the 1982 Convention extends the provisions of Piracy Urgentium to the exclusive economic zone, which has been referred to, that is in some regions where it's possible, is 200 miles. Hence, Articles 88 to 115 of UNCLOS, which concern high seas piracy, apply in the exclusive economic zone. I wish to observe that there is no agreement among commentators on whether or not the definition of Piracy Urgentium is adequate. Some view the definition in Article 101 as rather narrow because it covers the high seas and excludes the territorial sea. Others are of the view that rules concerning piracy under international law have been settled by the Convention of the 1982. Given the delicate package that was adopted by UNCLOS 3, I am of the view that it may not be feasible to attempt any redefinition of piracy in the immediate future. Furthermore, the current definition of piracy in the current definition of Piracy Urgentium has entered the realm of customary international law. I shall now consider the related problem of armed robbery. The Djibouti Code of Conduct concerning the repression of piracy and armed robbery against ships in the West Indian Ocean and the Gulf of Aden defines armed robbery, and I will not repeat the definition due to time elements. This definition of armed robbery is also to be found in the IMO Code for the investigation of crimes of piracy and armed robbery against ships of 2002. The Yaoundé Code of Conduct, that is Yaoundé in Cameroon, for West African states, concerning the prevention of piracy and armed robbery against ships and illicit maritime activity of 2013, has similar provisions in the definition of armed robbery. The Yaoundé Code, however, goes further than the Djibouti Code by providing for illegal, unregulated, and unreported fishing, IUU fishing. The Djibouti, the IMO, and the Yaoundé codes are all based on the Regional Cooperation Agreement on Combating Piracy and Armed Robbery Against Ships in Asia, RECAP of 2004. Unlike the Djibouti and the Yaoundé codes, the RECAP is binding. The RECAP provides for information sharing. While the above definition of armed robbery, which I referred to, contains some elements similar to those of piracy, it is different from piracy because it involves one ship and the actions take place within a state's own jurisdiction. Another instrument for the fight against armed robbery is the 1988 Convention for the Suppression of Unlawful Acts Against the Safety of Maritime Navigation, called the SUA Convention, which was adopted to fill the lacuna in the UNCLOS and instruments on armed robbery, which I cited. The SUA Convention was prompted by the hijacking of an Italian cruise ship, the Achille Lauro, in 1985. Offenses covered by the SUA Convention include seizure of a ship by force, performance of an act of violence against a person on board a ship, and damaging a ship or its cargo. The convention applies to straits used for international navigation in addition to the territorial waters. States parties must make convention offenses punishable under their laws. States parties must establish their jurisdiction over the offenses committed against their flagships in their territorial sea or by their nationals. There is a 2005 protocol to the SUA Convention, which adds to the offenses listed in the convention itself. I now turn to the root causes of piracy and armed robbery. The root causes include poverty. I think we have seen about when there was consideration of the SDGs that the first goal of SDGs is poverty. The people in high-risk areas, especially in the Gulf of Guinea, do not benefit from the natural resources. For example, Nigeria produces 2 million barrels of oil a day. It exports nearly all its crude oil and has capacity to refine less than a quarter of that oil. The situation is compounded by the fact that the oil-rich delta region of Nigeria does not benefit the ordinary people. The people in the Niger Delta, because of the subsidized oil being sold in black market, suffer from a lot of economic disadvantages. The poor people in the Gulf of Guinea and the Somali coast are forced to piratical attacks with consequent hijackings and kidnappings as a way of life. There is thus a need for the governments concerned to address the burning issue of economic disadvantage in order to fight crime in the hydrocarbons and shipping sectors. Another root cause is piracy. Another root cause of piracy is IUU fishing. The twin evil of IUU fishing and piracy are a major problem in the Gulf of Guinea, which is one of the richest fishing regions in the world. The phenomenon of illegal fishing not only makes Africa lose fish, but also makes it lose license fees. Most of the IUU fishing takes place in the EEZ. It was in this context that 7 West African states requested the International Tribunal for the Law of the Sea to render an advisory opinion. The tribunal answered 4 questions, which I shall not go into due to lack of time. It has liability for the states that long water distant fishing nations that come to fish off the West African coast, including international agencies. In this particular time, the international organization being referred to is the EU, because it's the only one that has fulfilled the requirements under Annex 9 of the convention in that category. This advisory opinion of 2015 has helped the Sub-Region Fisheries Commission of the 7 West African states on how to deal with fishing activities, IUU fishing activities by foreigners. In the process, the tribunal has made an important contribution to the reduction of IUU fishing. I turn to the challenges. In view of the prevalence of the armed robbery, the international community has been cooperating. The EU and NATO have been involved. Private maritime security companies have increasingly got involved in the fight against piracy and armed robbery. Doubt has been raised about the legal status of these private companies in the fight against maritime violence. One of the legal issues raised by these companies is whether the right of innocent passage under the convention applies to them. Article 19, paragraph 2 lists 12 activities that are prejudicial. Article 18 provides, in paragraph 2L, that any other activity not having a direct bearing on passage. This paragraph could be interpreted to include in the prejudicial activities to innocent passage private maritime security companies. One concludes that private armed guards do not have a right to stop or arrest a suspect ship. International law as it stands currently does not seem to give legal authority to private companies to enforce action against piracy. I would be interested to hear the views of the Coast Guard on this. UNCLOS provides that a warship or military aircraft or other ship or aircraft of governments may carry out seizure of piracy. An interesting situation arose in the Enrica Lakes case between Italy and India. This came before the tribunal. They had different claims, but the ITLOS called upon both parties to suspend all court proceedings pending a decision by Annex 7 arbitral tribunal. The case is still pending before the Annex 7 arbitral tribunal. I may skip some of the provisions I put down concerning the way forward in the West African situation, as well as the Article 98, which concerns the issue of providing humanitarian assistance to people who are wrecked, like in the Lampedusa situation, where you have people who come from the African and the Middle East area seeking some asylum in Europe. I just wish to conclude by making some observations. The International Tribunal for the Law of the Sea does not have jurisdiction to deal with piracy. This may sound strange, but that is the situation. Action is left to states to prosecute pirates. Hence, it is important for states to enact national law on the matter. In my opinion, states parties to UNCLOS can request for an advisory opinion on piracy from the International Tribunal for the Law of the Sea. Secondly, states that have not yet ratified the convention and the SUA convention, which I referred to, should be encouraged to do so. Thirdly, regional instruments such as the Djibouti, Yaoundé, and Yaoundé Cause should be upgraded from non-binding to binding instruments, just like the RICAP. Information exchange is crucial in the fight against piracy. Fourth, there is need to address the question of lack of capacity by states in areas affected by piracy. There should be more international cooperation in combating piracy and armed robbery. As most maritime violence occurs in areas of national jurisdiction, the capacity of coastal states, in particular the developing states, should be strengthened. The crimes of piracy and armed robbery should be taken seriously and given priority by the international community in the same way it does with regard to genocide, war crimes, crimes against humanity, and international terrorism. I thank you for listening in spite of the late hour. Thank you.